and turn the video. All right. Okay, good morning, everyone. This is the detention docket for the 323rd District Court. I'd like to announce that in compliance with the Texas Supreme Court 22nd emergency order regarding the coronavirus, we are not having any in-person court proceedings unless necessary, or unless it's not possible to do so. But in order to comply with the Texas Constitution, Article 1, Section 13, the otherwise known as the Open Courts Act, since we are not allowing people into the courtroom in observance of County Judge Glenn Whitley's order, we are broadcasting this proceeding on YouTube so the public has access to these court proceedings. No portion of this proceeding may be copied, recorded, or broadcast in violations that are punishable by contempt of court. All right, so we're going to go ahead and start with the gentleman that's in the Tarrant County Sheriff's custody, Mr. Mendoza. Okay, that's right. Okay, hello, Mr. Mendoza. So do you understand English?
No.
No? Okay. We're going to have Mr. Allard, do you just want to go and explain the rights to him after I do? I just want to make sure he understands. I want to make sure he understands his rights.
Yeah,
all right.
of course.
Mr. Mendoza, this is a detention hearing. While you're in custody, every 10 days, you have to see a judge to make sure if I need to decide whether to keep you in custody or not. You are an adult, so you're held in the Tarrant County Jail, but you're still entitled to these 10-day hearings. You have a right to an attorney, but if you cannot afford an attorney, I'll provide one for you. And you have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Mr. Adler?
Thank you, Judge. Señor Mendoza, soy Frank. No sé si se recuerda de mí, soy su abogado. Cada 10 días usted tiene el derecho de tener una audiencia de detención, porque el caso todavía es juvenil, pero como usted es adulto, está en la cárcel de adultos, tienes el derecho de no hablar, y yo como su abogado, yo voy a hablar por usted hoy, así que no quiero que digas nada. ¿Está bien? ¿Y entendiste todo?
Sí, está bien.
Okay, gracias. Judge, I did the best I could for all the Spanish speakers on there. I expect no critiques.
Mary is silently judging you.
Okay.
Okay, so, all right, so Mr. Mendoza, originally back in 2003, you're arrested for a felony case. The court found you unfit to proceed and sent you to Mejia State School for competency restoration. And then you were brought back. Then Judge Boyd found you unfit again, so we sent you back to Mejia. You were accidentally released, and then you disappeared for approximately 17 years.
Señor Mendoza, que usted tenía un caso de juvenil en el 2003. Y en ese caso, la jueza Boyd demandó a usted a ver si usted entendía todo lo que estaba pasando, y eso fue en una facilidad que se llamaba Mejia Escuela de Niños. Y cuando usted estuvo en esa escuela, usted se fue sin permiso, y eso fue hace 17 años atrás, y los encontramos hoy con su caso del 2003.
So now that you're almost 32 years old, there's a separate proceeding that we have to do to decide whether your case continues in the juvenile court or goes to the adult court.
Y en este momento que tiene 32 años, tenemos que tener una audiencia a ver si el caso se queda en la corte juvenil o si el juez va a mandar el caso a las cortes de adultos.
You ran from the court for about 17 years. I'm not comfortable releasing you because I don't think you'll show back up in court.
Usted corrió de la corte por 17 años. No estoy cómodo dejándote ir, así que te voy a detener.
Okay. So I'm going to go ahead and keep you in custody for at least the next 10 days.
Así que te vas a quedar ahí en la cárcel por lo menos los próximos 10 días.
Okay. Any questions, Mr. Mendoza?
¿Tienes preguntas, señor Mendoza?
Sí, que se podía hablar con usted. Así como...
Sí, usted y yo vamos a hablar, pero en este momento no podemos hablar porque el juez tiene muchos casos. ¿Está bien, señor?
Sí.
Hablamos muy pronto.
Gracias.
De nada. Judge, he just wanted to talk to me, and I told him he and I would talk privately and independently from today.
Great. Thank you, Mr. Adler.
Thanks,
All right,
Judge.
thank you, Mr. Mendoza. Sheriff, we're done with this inmate. Thank you very much for having him here.
Yes, sir. Thank you, Judge.
Adiós, señor.
That's right. I think he's already gone.
Was-
Right, the next one on the docket is Brian Carrera, Mr. Adler. I think he has actually already been picked up.
You know, I didn't know.
Yes,
I
I-
hadn't heard from Ms. Cook. That's great.
I think it was 10 o'clock this morning was when it was
Awesome.
scheduled. So
Perfect.
you're
Thank
still
you.
here, and so I'll still pay you for your appearance. But just to let you know, we were waiting for that for the transport. The transport
Yeah.
happened, so that's good news.
Great news. Thank you.
You're welcome. All right, next is Todd Dietrich with Mr. Lofton.
Good morning. It's a hard
Good
act to
morning.
follow Mr. Adler as normal, but I'm behind him all the way. So nice to see Lisa here, and Zane, welcome. So
Mr. Dietrich. All right, this is a detention hearing. All right, is Mr. Dietrich here?
I'm right here.
Okay, thank you, sir. So this is a detention hearing. The law says when a child is brought to our facility, you have to see a judge within the first 2 business days and have to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so Mr. Dietrich, you just turned 15 last month.
Yes, sir.
And then look. All right. So who's there? Who's security control with Mr. Dietrich?
What?
Okay.
I'm his
Mr.
grandmother.
Dietrich, who's with you?
David.
All right. Can you shut that door? That
Yes,
the noise
yes,
from the hallway is distracting.
Yes, sir.
All right. Thank you, sir.
You're welcome.
All right. So, Mr. Dietrich, let's see, your history of this department started when you were 10 years old. You're brought in for aggravated assault causing serious bodily injury and 2 counts of aggravated assault with a deadly weapon. You end up getting probation when you were 10 years old. I guess, Ms. Hall, did he successfully complete the probation?
Sir, he's still on until his 18th birthday.
Okay, wow, okay. All right, must have been a really serious case. All right, so we brought you in, your drug test, gave you a drug test, it was negative. Let's see. Almost 2 weeks ago, your mom contacted us because she's been having a lot of trouble with you at home. You're becoming assaultive and destructive at home, as well as leaving the home without permission. You went to a friend's house without permission, and Todd's grandmother had to call the police to get you back home. All right. So on August 3rd, Ms. Hall and her supervisor held an administrative hearing with you and your grandmother to address the issues, to try and direct you in the right direction. You refused to participate in the administrative hearing. And then when they were asking you to participate, you started cussing and throwing things. So they talked to your therapist, and the recommendation is to stay at the care house. They tried to present this idea to you, and you said you did not want to go to the care house. And so they told me about it, and I issued a warrant for you because you're not following the terms of your probation.
Yes, sir.
So you're currently on the waiting list for inpatient treatment at the care house.
Yes, sir.
They were supposed to have a bed open early last week, but the wait is now 3 weeks. So your PO is asking if you get to level 1 outstanding to release you back to your grandmother and an electronic monitor to wait for the bed to open up. All right. All right, that's absolutely reasonable to me. So Todd, this is where I'm at, okay? You're on probation. You know what TJJD is?
Where I'm at right now?
No, so TJJD, I think in 15, that was still, okay, it used to be called TYC a long time ago, all right? And what that is, that's prison for kids. So what happens is I can send a child, in your case, I can send you to TJJD, but it's not for a set amount of time. I just send you there. They say, once they feel like that you can behave and follow the rules and actually just be a good kid, then they'll let you out. It could be 1 day. It could be all the way up until your 19th birthday. I don't set the amount of time. Actually, you set the amount of time because it depends on how you behave while you're there. So that option is still on the table. I can send you to TJJD. But for me, that's the last resort. That I only do that when I'm absolutely convinced. When you, Todd, convince me that you cannot function here at your grandma's house. Okay. So that being said, I want to give you another chance. We'll look at Care House. But here's the thing. I am not going to release you to your grandmother to continue with your shenanigans. Okay? If you're in your grandmother's house, so you remember your grandmother did her job. She raised her kid. Okay. And she's done. She has no obligation to you. She loves you, but she doesn't owe you anything. Right? She is doing this just because she cares about you. But if you think about it, if you make it difficult for her, at a certain point, she cuts bait. She says, I'm just not going to deal with this. I dealt with this, 20 years ago. Right, Grandma? That's about right. 20, 30 years ago, maybe? I don't know how long it was since your child was 15. So, Todd, you have to understand, you are kind of earning your time at Grandma's, right? Because if we can't put you with Grandma, chances are you have to go to TJJD.
Yes, sir.
All right. So this is what I want from you. I am okay. Ms. Hall has always made reasonable requests. She's going to bat for you now. And you know what? I'm going to respect that. I'm going to do what she's recommending. I probably, if it was left to me, would have just kept you here until Care House opened up because of the problems you're creating for Grandma and how you refuse to participate in the administrative hearing. But since Ms. Hall is saying give you a chance, I'm going to give you a chance. I'm going to let you get to level 1 outstanding here. I will let you go on electronic monitor, okay, to be with your grandmother until a bed opens up at Care House. Okay. That being said, if you keep on causing problems here like you did at Grandma's home before, you're not going to get out of here. You'll be here for the next 3 weeks until Care House opens up. Okay.
Yes, sir.
If you get to level 1 outstanding and I let you go, and then you're causing problems with Grandma Grandma tells Ms. Hall tells me, and I just keep you here. We do it again until so you can be in and out of here for the next 3 weeks, or you can just go home, follow your grandma's rules, and just stay home.
Yes, sir.
So there's an easy way and a hard way, but you understand I have no control over that. Ms. Hall doesn't, Grandma doesn't. It's completely up to you. It's your decision whether you're going to follow her rules. And here's the thing. The reason why I'm saying level 1-0 here for you to get out, because that proves to me you have the ability to follow the rules. If you can get to level 1 outstanding here, that means you have the ability to be level 1 outstanding at your grandma's house.
Yes, sir.
See why I'm doing this? I'm kind of setting you up to prove to me you can do it. You can't come back and be like, well, Judge, I can't do it. That's just not me. Well,
Yes,
if it's not you, then you'll never get out of here. All right, we're on the same page?
yes, sir.
All right, so I'm empowering you. I'm putting all this in your hands so you can make decisions, good decisions, right? But you can make the decisions to go home. It takes 3 days to go up from level 2 to level 1. You're level 2 from what I see because you were just brought in. They'll reassess you every 3 days, and when you get to level 1 outstanding, I'm okay releasing Grandma. Grandma, does this sound fair?
Yes, sir.
Okay, Grandma, you understand I'm doing this because I'm trusting you that if Todd is causing problems, that you will call Ms. Hall. Do I have your promise?
Yes, sir.
Okay, fantastic. All right, Todd, hopefully I will not see you in 10 days, okay? All right, thank you.
They have excused, Your Honor.
Yes, Mr. Lupton, thank you.
Thank you all, everyone. Good morning.
Thank you, Judge.
Thank you, Ms. Hall. I think you did Mr. Lupton's work for him today.
Thank you.
All right, Ashley Kent is the next one. All right, is Ms. Kent here?
Yes, sir.
Okay, there we are. Thank you. And Ms. Mills. Oh, is Ms. Mills here? No, I don't see Ms. Mills. So, Ms. McGonigal. Ms. McGonigal?
Your Honor.
Okay, there we go. I'm asking you to fill in for Ms. Mills
That's
as
fine.
his attorney. So, all right, Ashley, this is the detention hearing. The purpose of this hearing is when a child is brought to a facility, you have to see a judge within 2 business days and have to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I'll provide one for you. All right, so Ms. Kent, let's see. You just turned 15 last month. You've never been here before. So, let's see, on August 6th, you were referred by Euless PD for the false statement. Oh, that's right. I remember this one. Why did I say we were setting this?
I was supposed to have you here with CPS.
Okay,
Honor.
is CPS here?
Yes, is here. You wanted me to have it released to the stepfather. Unable to locate the stepfather.
Okay, is the department here?
Yes, I'm here.
Oh, okay.
This is
hello,
Megan.
Barbara.
Sorry, I was trying to figure out how to unmute myself.
It's okay. So my understanding, I remember somebody telling me, is that CPS was looking to take possession of this child.
So we had an open investigation that was basically called in as a result of a companion investigation regarding Miss Kent's niece and nephew. There's nothing to investigate, but if Miss Kent's mom has not been released and cannot collect her child, then it's my understanding that ACH was, and technically that can be considered a reason for us to remove. It's not a great reason. We don't love that reason. She appears to be doing pretty well at home as far as having a job and stuff like that. But if her mom's not out of jail, elect her, then.
And then father can't be, I think father actually or stepfather kind of absconded from the situation.
It's my understanding, yes.
Right.
It
All right,
has been
so,
alleged.
I'm sorry, Mr. Kroll?
That it has been alleged, correct.
Okay. All right, so Ms. Barber, here's my thing is, what I'm seeing this is about the false police report that mom and brother also got arrested on.
Mhm.
I really would not like to keep Ashley here. I don't think this is at this point an appropriate situation for her. There may be other times when it is appropriate. I just don't think this one is.
Mhm.
And we really don't have anybody to release this child to.
Got it.
So what can we do?
So, I mean, in order for us to take possession of a child, we have to, write an affidavit and submit it to the judge.
Mhm.
I've never had the instance where anyone has ordered a child into care, like right now. I've not ever had this happen. But I mean, if that's what we have to do, if we have to order her into care and maybe non-suit it when mom gets out, does that
Okay,
sound
No,
reasonable?
that sounds
Okay.
very reasonable.
So I can submit it to I can submit it to OCOK. My question is what do you on this side, because I don't have a CPS attorney present. So if you can give me, a little bit this morning, get with one of our attorneys and ask what documentation I need to submit to the court.
Sure.
Does that
No,
work?
that's fine. I think it'd just
Okay.
be an emergency possession
Removal.
of the child.
Okay.
Because
Okay.
there's no parent to take the child. If you
Right.
need me to sign that to make it easier, I don't mind doing it. Judge Brown is downtown. She can do that as
Okay.
well, or
Okay.
any other district judges downtown.
Okay.
Whatever's easier for you guys. Can we set so if we can set a kind of a window for this, just so.
Yeah, I mean, I can submit the placement recommendation, okay, in the next hour, and they'll have 4 hours to find a placement for her.
Fantastic.
And then
Oh no, there she froze.
I'm gonna need to
Okay.
speak to her so that I can find an
Ms.
appropriate.
Barber?
Is there any way for me to?
Wait, Ms. Barber?
I couldn't hear you. You were frozen.
Okay, there we
Okay.
go. You froze up, so the last thing we heard is you can send the request and they would
And-
have to act within 4 hours.
4 hours. And then, but I do need, in order for me to send a good request, would it be possible for me to talk to Ashley? I don't know if I can do it via Zoom. I'm kind of tethered to my desk for the moment. If I could talk to her just so I can get a good placement for her for the time that she's going to be there.
Okay, what we can do is we have a certain number of computers,
Uh-huh.
so we have to finish our detention hearings.
Okay.
You can either call our facility and
Okay.
Mr. Kroll can get you the number so you can talk on the phone.
Perfect.
If you would like to do it through Zoom, that's fine.
Phone
but
is fine.
you'll have to wait till probably about noonish or so.
No, a phone is fine. I'd rather get it done sooner than later, so I can
Okay.
call. Okay,
Do you have Mr. Kroll's number?
I do.
Okay, yes, just call him and he can set up the phone call. Actually, I know this is frustrating for you. If anything, this means I don't want you here. There just has to be a place to release you. I cannot put a 15-year-old girl out on the streets. Right? That's not part of my job. So I have to have a place to put you with a responsible adult. Okay. So, but trust me, you would rather be at a temporary placement than here at Kimbo. Okay. I know you'd rather be at home with your mom, but that's not an option right now.
Is there a way I can speak to my mom?
I'm sorry?
Is there a way I can speak to my mother?
So maybe, not from here, because there are absolutely zero phone calls from our detention facility to the adult jail, and that's by federal law. I cannot have you talk to anybody there, even if they are your mother. Okay? It's federal and state law, since your mom is in custody downtown. Right? Now, that being said, once you get out of here, you can call your mom, or if your mom gets out, she can call you. But there are many laws that prevent a juvenile that's in custody from ever talking to an adult who's in custody. Okay, so that's where the wall is that nobody can get around. All right. So this is not the news that you want to hear, and I'm sorry, but I hope you understand that Ms. Barber, Mr. Kroll, myself, Ms. Mills, we're all trying to do what we can to get you out of here. Okay.
Sure. Yeah.
All right. Thank you, Ms. Barber. I appreciate you being here.
No problem. I'm going to call Mr. Paul now. Thank you.
All right, thank you. The next one is Joseph Navarez.
Just talk about it.
All right, Mr. Navarez?
Yes, sir.
Hello, I'm Judge Kim. This is a detention hearing. The purpose of this hearing is to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 business days while you're here. You do have a right to remain silent, but if you give up your right to remain silent, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so Mr. Navarez, you are 16 years old, and then so you have never been here before, but you're on probation out of Dallas County for an assault until January of next year. Dallas County placed you at a facility from January of this year until July of this year, in January of 18 to July of 18. Wait a minute, so you've been in placement up until last month for this whole year?
Yes, sir.
Okay. So you've been on intensive supervision twice, and you've been on electronic monitor 3 times. All right. Okay, so let's see. Yesterday, Fort Worth PD brought you in. They said around 4:50, the police were dispatched at 2000 Main Street regarding a shooting. When the officers arrived, they met with the victim, who was shot multiple times and treated at the hospital. An off-duty officer witnessed the incident and saw Joseph Navarez stand over the victim, pointing a black handgun, and fired a round at him. Joseph then jumped into a tan GMC truck and headed southbound on Main. The off-duty officer followed the truck until assistance arrived and apprehended Joseph Navarez and his companion, Brian Rivas. Detectives interviewed both juveniles. Joseph admitted to detectives about the shooting and the theft of the victim's bag. So our offense report didn't say anything about theft of the bag. Is there something missing, Ms. Guerrero, or?
We haven't gotten the full report yet. We
Okay.
just,
Okay, so he admitted to the shooting and the theft of a bag, but I don't know anything else about the bag yet. Okay, so there's security footage showed Joseph committing the shooting and theft. Brian made a res geste statement that he knew Joseph was going to rob the victim, so they were both transported to our detention facility. All right, go up. Mr. Navarez, I think you need to understand that here, I know it's your first interaction with Tarrant County, but here in Tarrant County, as the juvenile judge, I take children with guns with the highest level of seriousness. I just do not tolerate kids having guns unsupervised. Right, if your parents are with you, that's one thing. If you're by yourself, I have an issue with that. I think you're a danger to the community. I think you're a danger to yourself. I'm glad nobody else around you had a gun at the time that would have shot you, most likely, here in Fort Worth, in the stockyards. Anyways, so at this point, I'm going to go ahead and detain you. And this case will proceed. You have been appointed an attorney. I think, Ms. Guerra, have we notified Dallas of this?
Yes, Judge, we have.
Okay. Have they issued a DTA?
No, they haven't. I just looked and they have not.
Okay. Well, it's
Hey,
still
sir.
Monday.
Sir, can I ask you a question?
Yes, sir.
So you know what my charge that I'm facing right now?
Yeah, you're looking at, well, they said aggravated robbery. I don't know if there's enough for the aggravated robbery. I know there's enough for aggravated assault with a deadly weapon, right? So if you were, potentially if you're certified as an adult, you're looking at up to 20 years in prison. If you stay in the juvenile, as an adult, you would look at between 2 and 20 years in prison. As a juvenile, you're looking at 0 years up to 20 years in commitment with a possible transfer to adult prison before your 19th birthday. Okay. Now that's on the aggravated assault. If this turns out that there's enough for an aggravated robbery, which it kind of indicates it might, you're looking at, if you're certified as an adult, up to 99 years or life in prison. Okay? So I just want to let you know, these are very serious matters. The best thing you can do is help your attorney, right, by keeping your behavior level high. If you keep your behavior level 1.0, that is evidence that can be used to help you in your case. And
Hey, can I ask you a question?
Well, can I finish my sentence first?
Yes, sir. My bad, son. Sorry.
That's all right. So if your behavior level is 1 outstanding this whole time, then that gives the attorney a chance to argue why you deserve probation because you've changed. I do believe juveniles change. They can be redeemed. I'm not a judge that sends a kid away and buries them under the jail. I believe every kid can be saved. Some children choose not to, but they all can be. Now, here's the thing. If your behavior level goes down, you're like level 3, you're getting in fights, like, I don't know, maybe you're in a gang and you're doing gang-related stuff here at our facility, then the DA will use that. Here, the DA is one of these Zoom sessions, and they're taking notes, and they will use that against you and give a reason why you need more punishment or go to prison. Okay? Now, what was your question?
Sir, I was going to ask you, ain't no chance y'all can send me to TYC?
Oh, yeah, absolutely. That is a chance. I can't see, as a judge, I can't predict what I'm going to do. I don't have all the evidence. There will be a trial, and at the trial, the district attorney will have the chance to present all their evidence. Your attorney will have a chance to produce all of your evidence. And then as a judge, I'll make a decision. If your attorney decides that they don't like me in this case, then a jury would be able to make that decision. And TYRC is an option. That would be part of probation, though. Okay, so right now it's the idea of, do you get committed to TJJD, which is prison for kids, all right? Right now, this is what's called an indeterminate sentence. So today, if you get committed, then you go to TJJD all the way up to your 19th birthday. It depends on until you actually rehabilitate and you make changes and you show that you're safe to release. Now, if the DA tries to certify you as an adult, then TJJD is no longer an option. You're looking at TDC, and you could be there up until you're 99 years or for life. Okay. So I'm just letting you know, these are the possibilities. TYRC is possible. I do need to let you know that I think the general word on the street is I'm a little tougher than Dallas County. Okay.
No, I ain't gonna lie, I heard about that though. Like, you know what I'm saying? Like, I am in Rodriguez, but you know, like, you know what I'm saying? Like,
Hey, Joseph,
sir.
stop talking, okay? We'll talk later.
Okay. That's your attorney, Frank Adler. If your attorney's advising you not to talk, I advise you to follow his advice. Okay.
Yes, sir, my bad, so I'm sorry.
No, that's all right. This is not your trial. This is not about whether you did or not. I'm not sentencing you or giving you probation, anything like that. Right now, I'm just letting you know I'm not going to let you go because I think you're a danger. Okay?
Yes, sir.
All right. Thank you, sir.
Thank you, Judge.
Thank you, Mr. Adler. All right. Daniel Pena. All right, Mr. Pena. Waiting on Mr. Pena. All right. The next one, Bethany Renteria. Bethany Renteria, please. Okay. Brian Rivas. Can we have Brian Rivas?
Judge Kim,
Yes?
Bethany is assigned to me, but I don't see her.
Yes, I know, and I'm not blaming you. All right, Brian Rivas for the third time. The fourth time, Carlos Santos. Carlos Santos? Detention, I need Carlos Santos.
Judge Kim, all the kids you're calling are from Hotel Pod, so Mr. Hector's up there.
All right, Jajuan Varela. Jajuan Varela. Jajuan Varela.
Judge, I have a Nathaniel. He looks like he's the one next.
Well, yeah, 3 minutes ago. Like, where was he?
We're putting his PPE on, sir.
Okay, so I mean, I'm not trying to bust on you, but why would this PPE on and him ready to go? I mean, and I'm not saying it's your fault. I'm saying what is the policy? Do they just not pull the kids out of the room until after I call their name, or was he causing problems?
No. He was inside his room, and protocol didn't allow me to have his PPE all inside. So whenever he came out, that's when he proceeded to put it on. So they're not allowed to have either the blue gown and the gloves inside the room.
I mean, I get that. So how many more kids do we have to put on? How many more kids are on Hotel Pod?
We, after him, we have 3 more, sir.
So are we gonna have to wait between each one?
No, it was a miscommunication between me and him.
Okay.
I advised him as soon as the last youth came out of his room to proceed and put his stuff on. He misunderstood me. That was a issue, sir.
Okay, I can live with that one. That seems legit. All right, so you're Nathaniel Pena?
Yes, sir.
All right, I'm Judge Kim.
Can I lower my mask?
You can lower it if you'd like. So this is a detention hearing. The purpose of this hearing is to make a decision whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, Nathaniel, you are 16 years old, and see, previously you were here when you were 12 for an assault bodily injury. You got deferred prosecution from our probation department. And then, let's see, you're still 12 years old. You get a contempt of court charge. Ed, do you remember this one? This is another Tim. Okay. And then you're still 12 years old. There's interfering with a 911 call. And then 2 months later, you pick up an assault family violence, which you got probation for. Mr. Ainsley, is he still on probation?
Judge, this one's mine. He is not on probation. He completed it.
Okay, good. All right, Nathaniel, let's see. On August 7th, around 10:20, police were dispatched for a call about somebody with a gun. The police ordered the occupants of the house to get out. 4 females exited, and then Nathaniel complied and exited. Your mom said to the police that you were upset, saying that someone took $300 from you. When no one responded, he went to one room where he flashed his gun to one sister. And then according to Sister Nathaniel, never pointed a gun or said he was going to shoot anybody. When the officers got consent to search, they found a backpack hidden in the dryer. The backpack contained a Smith & Wesson 9mm, 0.38 grams of a green leafy substance, a controlled substance believed to be mushrooms, as well as gloves. So you're arrested. Miss Blair, were the drugs found in the backpack?
Yes.
Okay. All right. So, all right. Well, and we're testing you and you're positive for marijuana. And I guess that DPP and probation didn't really help you that much. Okay, well, Nathaniel, that's one thing. If you think family stole from you, but it's crazy to think that you would flash a gun at your own blood. Listen, Nathaniel, I see your hand. So let me say something first. You have the right to remain silent. If you want to talk about this case, I probably advise you not to. This is not your trial, okay? This is simply about whether I think it's safe to release you or if I think it's better to keep you here in our detention facility, okay? That being said, is there something you want to say or do you have a question for me?
There was something I wanted to say.
Okay, if it's something you want to say, if it's about what happened on the 7th, my advice to you and your attorney's advice to you is not to say it at all, okay? Because probably cannot help you. Now, if you want to talk, you certainly can. Yes, sir?
Can I speak to my mom real quick?
Well, your mom can call you, right? But I'm not going to stop our whole detention docket so you can have a conversation with your mom, okay?
Yes, sir.
So, all right. That being said, Mr. Pena, I have great concern anytime we have a kid with a gun. That's just one of those things that I've established since I got here, is I do not tolerate children with guns unless they're supervised by their parents, okay? The fact that there's drugs involved also, that gives me even bigger concern because you would be amazed how many kids get shot or shoot people over something silly like weed, okay? Happens every day. So this makes me very uncomfortable to release you. What it looks like is, well, one, it looks like you had a gun. Two, it also looks like you had a gun and you're dealing drugs. And so either buying or selling, and that gives me great concern too. So I think you're a danger to yourself as well as the community. I'm gonna go ahead and detain you for now. That's not to say I'm not gonna release you. I'm saying right now I have to be comfortable before I release you, okay?
Yes, sir.
All right, thank you, Mr. Pena.
Thanks, Judge.
Bethania Renteria. This is a really simple formula, I think. Kids and guns.
Here,
All right, Bethany?
here.
Hello, I'm Judge Kim. This is a detention hearing. So the law says when a child is brought to our facility, you have to see a judge within 2 days. Wait, this is, oh, okay. You have to see a judge within 2 days and I have to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so Bethany, you have never been here before. You're almost 16 this month. All right. Let's see. On Saturday, the police are working on an attempt to locate a youth after receiving a call from the youth's mother. Mom said that the girl was asking for mom to come and pick her up, but the mom wasn't able to do so since she was in Austin. She was located at the laundromat on Alta Mesa. Around noon, when they got there, they went in there. They found the female matching the description and an unknown white male seated on a bench with a phone between them. When they asked her if her name was Bethany, she said yes. So they confirmed that you were a runaway as well as confirmed with a tattoo. Hey, Bethany, you're 15, you already have tattoos? Oh, come on. See, look at you right now. You're not proud of it, right? I mean, maybe at the time you thought it was a good idea, but see, when you do things like tattoos, you know you're setting up this conversation later on, right? And it may be a great tattoo, it may be a beautiful tattoo, but I can tell right now by your body language, you're not proud of the tattoo. Is that fair to say?
Yes, sir.
Okay. Don't worry, I'm not judging you on the tattoo. I just want to have that little conversation with you. Okay, so, well, I got a question. Ms. Lazarova, what is the tattoo of? Do we know?
I can find out in a second.
Okay. All right, so the officer puts you in handcuffs. You're placed in the back of the car and brought to our detention facility. They confirm that you are on probation out of Austin for criminal trespass. Your probation was to expire August 13th. So now you're facing 3 counts of assault of a peace officer or a judge from November of 18, July of 19, and April of 20, and failure to ID in May of 20. They issued a warrant on August 7th for a violation of court order. So they are planning on coming and picking you up on Monday before detention hearing, but I guess they didn't make it. And so Okay, today they told us they're picking up tomorrow to take you back to Travis County. All right. So, Ms. Lazarova,
Yes, sir.
there is an active DTA from Travis County, correct?
Correct. That's correct.
Okay. All right.
They have said that they will come and accept custody tomorrow.
Okay. By the way, Ms. Lazarova, I do miss talking to you over the weekends on these.
Oh, yes, sir. Me too. Nice to see you.
Okay, so Brittany, here's the deal. What the law says is when a child is brought here, I have to find there's probable cause that you violated the law. Okay, that means can somebody put into words if you assume that it's true that you broke the law? Then the fact that a judge signed a warrant out of Travis County, I can assume that it's a valid warrant. Okay, so the next step is to have it feel like you're not going to appear. This is basically there's a warrant for you out of Travis County, and so I'm just going to hold you until they pick you up tomorrow. Okay, so just letting you know you're going back to Austin. Okay, there's not much you can do about it. Hopefully you get your things straightened out. I hope things are okay with you, Brittany, and I mean that like sincerely, like heart to heart. Like I know there's a lot of things going in your life. I hope things get better. I'm just saying this because I'll never see you again, but a lot of times bad things happen. Good decisions come from experience, and experience comes from bad decisions. Okay, every adult will agree with that. So hopefully the situation that you're in right now is something that you made some bad decisions, but you're learning from this. That way, looking forward, becoming a young woman, that you can make better decisions. Looking back on the mistakes that you made. Fair enough? Sorry for being all preachy on you right now. I just know I'll never see you again, so I'm just trying to give you words of encouragement that nothing's so bad, the situation can't get worse, but it can always get better. Okay? Okay, thank you, Brittany.
Thank you, Your Honor.
Next, Brian Rivas. Hello, Ms. Beaver.
Good morning, Your Honor.
Good morning. Hey, Mary had talked to me about the one where you filed a motion withdrawal. You can set it for hearing, but you know, with court appointments, it kind of sets a different standard on withdrawing.
Okay, Your Honor, I did just receive today the signed motion from the respondent.
Yeah, but can you promise me that she's not going to have problems with the next attorney I appoint?
Your Honor, I don't know that I'm able to make that promise. I'm sorry.
Now you see my problem, right? So, but yeah, that is the burden every court appointed defense attorney has, right, Ms. Herrick?
If you would like me to reach out to her, I will, and perhaps I could speak about this later.
Right. Come on by or call me or whatever.
Your Honor, the parents are asking if anybody can speak Spanish.
Thank you, Your Honor.
Oh, you're welcome. All right, Mr. Beaver. All right, so were you here earlier when we did the companion case on this?
I was, Your Honor, yes.
Okay, good. So I'm just going to admonish the child. And Brian, you speak English, right? So yes?
Yes.
Okay. So Mr. Beaver, I'm going to admonish Brian, and then I'll give you a chance to go ahead and tell the parents what Brian's rights are. Okay.
Thank you, Your
Mr.
Honor.
Rivas, this is a detention hearing. The purpose of this hearing is to make a decision to keep you in custody or release you. This is not your trial, okay? You have certain rights. So when you're brought into our facility, you have to see a judge within 2 days. I have to decide whether to release you or keep you in custody. If I release you, or if I keep you in custody, the law says you have a right to see a judge every 10 days while you're here. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you do have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, Mr. Beaver.
Thank you, Your Honor. Señorita Rivas, habla Larry Beaver, soy el abogado. Ya hablamos hoy, usted y yo. El juez estaba dándole los derechos a su hijo sobre este proceso hoy, la audiencia. Y su hijo tiene el derecho de tener una audiencia con el juez dentro de 2 días de haber sido detenido. Y cada 10 días tiene el derecho de volver a hablar con el juez para determinar si él debe de quedarse detenido o no. El proceso hoy, la audiencia de hoy es nada más para determinar si él va a quedarse detenido o no es el juicio hoy. Okay. Nada más para determinar si va a quedarse detenido. Y Brian tiene el derecho de permanecerse callado Si él decide que no quiere permanecerse callado, entonces el fiscal del estado y el juez no puede usar lo que diga en su contra en el juicio. Ya hablé con Brian sobre eso y si Brian quiere hablar conmigo, Brian, por favor, levante la mano si quiere hablar conmigo. Okay, gracias. Thank you, Your Honor.
All right, thank you, Mr. Beaver. All right, so Brian, you are 16 years old. You've never been here with this department before. Mr. Ansley, is he from Fort Worth, from Tarrant County?
No, Judge, it's assigned to me, but he resides in Dallas County.
Okay. All right, so yesterday, Brian, the police are saying at about 4:50, police were dispatched to 2000 Main Street here in Fort Worth about a shooting. When the officers got there, they met with a victim who was shot multiple times and treated at the hospital. An off-duty police officer witnessed the incident and saw Joseph Navarro stand over the victim, pointing a black handgun and shot a round at him. Then Joseph jumped into a tan GMC and headed south on Main. Off-duty police followed the truck, waited for assistance, and they apprehended Joseph and Brian Rivas. Mr. Ansley, was Brian the driver?
Judge, the report did not detail that, but when I spoke with the parents, they did say that Brian was gone yesterday with Dad's truck.
Okay. And Dad has a tan GMC truck?
I did not confirm that with Dad.
Mr. Beaver, can you ask Dad if he has a tan pickup truck?
Yes, Your Honor. Señor Rivas, ¿usted es el dueño de una camioneta GMC de color café claro?
Sí.
So, yes, Your Honor, he is.
That's tan in Spanish? Café claro?
Yes, sir.
That is. I was waiting, Mr. Beaver, to see how you would say tan. All right. So, let's see. Detectives then interviewed both juveniles. Joseph admitted to the detectives about the shooting and theft of the bag the victim was holding. Security footage showed that Joseph committing the shooting and theft. Brian made a res geste statement that he knew Joseph was going to rob the victim, and both were transported to JPD. All right. All right, so Mr. Rivas, I'm going to let you know just because I went ahead and let your compadre know that in Texas, well, so we have something called the law of parties. Have you heard that term before? No? Brian? Okay, the law of parties is when two or more people get together and plan a crime, either plan, commit, or benefit from a crime together. They can all be individually and separately guilty of the same crime. Okay? So the example is, let's say you, or let's say me, your mom, and your dad decide to rob a bank. Okay? And we plan it in your mom's kitchen. She tells us how to do this. She stays home. Your dad and I go to rob the bank. And, you know, I'm the getaway driver. Your dad goes in, gives him a note, and says, I have the money. Well, the security guard there, this old guy, shaky hands and everything, starts shooting his gun, kills a customer. But during a robbery, somebody was killed. That means your dad could face capital murder charges, okay? But since I benefited, since I helped commit the crime as a getaway driver, I could also face the death penalty. Your mom, who helped plan this, could also face the death penalty. So in Texas, basically says anybody that is part of a crime together, they're all guilty of the same crime, no matter what role they have, okay? So it looks to me is that you're a part of at least an aggravated assault where somebody got shot, could be an aggravated robbery, right? But if you were a getaway driver, if you knew about it, you helped plan it or commit it, then you could be guilty of the same crime, even though you didn't actually have a gun or pull the trigger. That's just what our law is. I want to let you know how serious this is, okay? Because in here, if it's an aggravated assault, which is the bare minimum that I can see this as, you're looking at up to 20 years in prison, okay? And you'd be transferred to adult prison before your 19th birthday. If this continues as an aggravated robbery, all right, then this can go all the way up to 99 years or life in prison. Right? So we're talking about a very serious matter right now. So what I'm gonna do is I'm gonna go ahead and detain you because I'm not comfortable releasing you because there was a gun involved in a shooting, okay? Now that being said, nobody puts a gun in your actual hand. That certainly goes in your favor. It may mean that you get released sooner, it may not. I'm not making any promises, I'm just saying I recognize the difference between you and what they're saying that Joseph did. Now, back there, you understand these behavior levels. you need to be a 1-0. You need to give your attorney as much as possible, all right, to work on your behalf to get you probation or to fight your case. If you're level 1-0, it helps them. If you drop down, you're level 3 in our behavior level list, then that's something that the district attorney will use against you to say, this kid needs prison. Probation is not for him because he can't behave, okay? So pay attention to behavior levels, make sure you're following the rules that you're supposed to, all right? Now, because I'm detaining you, you have a right to see a judge every 10 days while you're here, okay? You have any questions for me?
No, sir.
All right, thank you, Brian. All right, Mr. Beavers, I know this is not the time, but if you can call the parents and explain what happened to them.
Yes, Your Honor. Thank you.
Thank you. Carlos Santos. Hello, Ms. Johnson. How are you?
Morning, how are you?
Doing well. Did you have a good weekend?
Well, it was okay.
I'm sorry. Oh, you know, pretty soon your bad luck's going to run out. You got nothing but
Let's hope.
It's got to happen that way. So, and you deserve a good streak of good luck.
I hope. I would like that.
Well, it's not that I hope. I know you deserve it. I just hope it comes.
Thank you.
All right. So, Carlos Santos, are you here?
Yes, sir.
Okay, there we are. Okay, Mr. Santos. So I'm Judge Kim. This is a detention hearing. The purpose of this hearing is to make a decision whether to keep you in custody or to release you. By keeping you in custody, the law says you have to see a judge every 10 days while you're here. You do have a right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. Okay, so Carlos, see what's going on. You have been here before, and you turn 17 next month. All right. So, starting when you're 14, you picked up a weed case. Our probation department gave you a supervisory caution. Then you turn 15, and you pick up a theft case, which the DA dismissed it. Then this year, you're 16, you take a weed case. Then we'd let you out, and in 2 weeks, you get arrested for weed again. For some reason, thought you need deferred prosecution. So it's his third weed case, and it's deferred prosecution because, you know, we can't see any pattern or problem here. And surprise, surprise, now you pick up another weed case. Like, Mary, one would think that he's just tired of coming here. But I guess there's something about marijuana that makes it worth it. Oh, that's true. Hey, so Carlos, is this the first time you've been inside Kimbo?
Yes, sir.
Okay. Well, that's Mary, eternally hopeful. All right, so we gave you a drug test, and you're positive for marijuana and cocaine and Xanax, benzodiazepines. Mom, are you here?
Yes.
Okay. You heard what I just said, right?
Yes.
Okay. The cocaine scares you and me both, doesn't it?
Yes, yeah. No.
All right, so police brought you in about 2:20 in the morning on August 7th. Even Friday. Mom, why was he out at 2:20 in the morning on a Friday morning?
I have no idea.
Okay.
I didn't know he was in home.
Right, okay. Now, Mom, I'm not trying to beat you up. I really, if you get to know me, I truly, I'm a big supporter of parents. Like, you and I need to work together. All right, so they were doing patrol on Brown Boulevard when we saw a white Chevrolet Malibu sitting in the parking lot of a strip mall. When they got there, saw a Hispanic male inside making furtive movements towards the passenger seat and reaching under the driver's seat. So the police called for backup, parked his patrol car. Carlos placed his vehicle in reverse and started backing up, at which the police initiated the traffic stop. Another officer got there. They made contact with Carlos. They were concerned because of his movements inside the car, so they just told him that they would search the car. At that time, Carlos admitted to having weed in the pocket of a backpack. They noticed a baggie containing a green leafy substance in the backpack at ½ ounce on a burnt glass pipe and scales. So he was placed under arrest. They also found a green rectangular pill in a coin pocket of his pants. Carlos said it was Xanax and said he did not have a prescription for it. What do you think, Mom?
To be honest with you, Your Honor, I think he needs help.
The kid's almost 17, right?
Yes.
And I know he needs help. So let me ask you this. And again, this is not me trying to beat you up, but this is kind of a pattern of behavior. Like, it seems to me he's needed help for a while. So why hasn't he gotten help before?
Because I really wasn't aware of what he was doing.
I mean, he's almost 17. I mean, it's not like you can physically hold him down. It's not like you can spank him anymore, right?
Right.
I mean, I get that. Well, here's the thing. All right. So, Carlos, my biggest concern, like, the weed is whatever. I mean, that's your choice to make. That's your choice to make. Cocaine really bothers me. Okay. Really, really bothers me. So I'll tell you what, normally what I would do is I would just release you on a drug patch to make sure you're not using drugs. But we're not doing drug patches right now because of coronavirus. And so I'm just going to go ahead and detain you until we start the drug patch program again. And once we do, then I'll go ahead and release you. Okay, on the drug patch to make sure you're not using drugs. This is just a consequence of your decision. Okay?
Judge, technically, nobody knows he had drugs on him. No drug tests have come back. No lab tests are back to say any of that. And if he could do UAs or hair follicles, it would be the same as the drug patch.
Well, not necessarily. The UAs will really be good on the marijuana, unless he's going to come in every 3 days on a UA. That would be the same thing as a drug patch. It's just, if he's willing to pay for it, yeah. I mean, so the cost to the county and the taxpayers on drug tests versus the drug patch is substantial, because drug patch we just do every other week. It gives a very immediate result.
But he could come in and do a UA once per week, and then the county wouldn't be spending money for him to live there every day either.
But the cocaine, right? I mean, the cocaine is the big problem for me. That makes it an every 72-hour issue instead of, and that's the thing about drug patch, is the 24/7 monitoring. The hair follicle, that's waiting for the results on the hair follicle makes it worse. And plus, if we did a hair follicle test every week for him, he would have no hair left, right? So that's another potential problem. We'll find out. Yeah, it's the cocaine that gets me. It's like, I'm not asking for the monthly, but you're right. I mean, we have that cost. So I'm trying to balance this out, Ms. Johnson. Like, I get it. We have the cost of detaining him versus the cost of the test. The problem is, if we're going to test every 3 days on a UA, the resources involved by the JPD staff to do that, I mean, I just need some kind of active monitor. If there was no cocaine, I'd just do monthly. I'm okay with that. The problem is with the cocaine, we're talking about 3 days for it to process. Like, it's got to be a 72-hour window on the drug testing. I'm open to suggestions, but those hard street drugs really bother me. Guns really bother me. And of course, he turns 17 in a matter of weeks now, anyways, where he would just go downtown. Right. So, at what point do we really worry? So, I don't know, Ms. Johnson. Come up with an idea. All right. I'm open to ideas. at this point, I want to settle the drug test, but Ms. Johnson, you've always been very persuasive with me. So I'm open to ideas.
Maybe I can ask the mom, do you have access to any kind of medical care that would include treatment and or testing?
We have insurance. I don't know if they'll be able to do it. Blue Cross Blue Shield.
Well, maybe we could set up a way, Judge, to do testing weekly.
Okay.
Weekly doesn't get me there because of the cocaine.
Can
right?
I have a question?
Yes.
How was the cocaine used? Was it in the marijuana or?
No idea. I just know he used it. So.
And it could have been something from 2 months ago. I mean, there's no way to know at this point.
No, it had to be in the last 72 hours. It was a UA.
Oh yeah, it was a UA. Yeah.
So yeah, he used it.
You're gonna remain silent.
Yeah. Your Carlos, your attorney does not want you to talk. I know that with certainty. So Mom, we know for a fact he used marijuana within 72 hours before Friday. So Tuesday, Wednesday, Thursday. Okay. So it was that recent. So yeah, which is scary because I'm sure you saw him Tuesday, Wednesday, Thursday. At some point when you saw him, he was high. Which probably makes you more concerned. So, yeah, Ms. Johnson, I'm open to ideas. The cocaine is the hanging point for me. A way of actively monitoring him.
Does the court have any idea when the patch may be available again?
That's up to juvenile probation department. That's really up to them. Like I have no control over that. It's their contract and their vendor and their nursing staff that administers that.
But if the parents' insurance company also had that option or had that availability, would the court be inclined to allow that?
If the insurance company will directly send the results to us, yes.
Okay.
Fine too.
Thank you.
Okay, thank you. All right, Carlos, so you understand where you're at, right? You understand why the cocaine is really getting to me. That's the hang up. If it was weed, I'll just do monthly testing and let you out. The fact that the action doesn't help. I'm sorry?
I honestly didn't know I had it, but.
Okay, hold on. Your attorney does not want you to talk. And here's the thing. It doesn't help you to lie to me. Lying to me never works. I'm telling you, you use cocaine, right? You may not have known it, but you used it. The way you test positive for cocaine is you use cocaine. That's the way it is, okay? So, all right, Carlos, so hopefully this is just something that you can look forward and make better decisions in the future, all right? All right, so I'm gonna go ahead and order you detained. Ms. Johnson, I am literally, honestly open to ideas.
Okay.
All right, so Jawan Varela. All right, Mr. Varela, I'm Judge Kim. This is a detention hearing. The law says when a child is brought to a facility, you have to see a judge within 2 days and have to decide whether to keep you in custody or to release you. If I keep you in custody, the law says you have to see a judge every 10 days while you're here. You have the right to remain silent, but if you give up that right, anything you say at a detention hearing cannot be used against you at any other type of court setting. Finally, you have a right to an attorney. If you or your family cannot afford an attorney, I will provide one for you. All right, so Mr. Varela, you are 16. Wow, you just turned 16 2 weeks ago. All right, you've never been here before. See, on Friday, Rectifying PD brought you in. They're saying at around midnight, police saw a vehicle driving without headlights and not staying in a proper lane, thinking the driver may be intoxicated. So there's a traffic stop. Driver swerved, accelerated to evade the officer, going up to 120 miles an hour. Lost control of the vehicle on a curb, striking a tree head on. The driver, Jawan Varela, attempted to flee on foot, but when the police drew his service weapon, ordered him to stop and get on the ground, Jawan listened to the officer. Noteworthy that Juwan had somebody on his phone who was egging him on and yelling he was recording the phone call. Additionally, Juwan made comments to officers bragging about speeds he reached and stated, "I saw your red and blue lights dusted you, bro. Fuck you. I was ready to meet my maker. That was crazy." When assistance arrived, officers checked Juwan for medical attention and transported here. It's determined that the car Juwan was driving was from the order his father was picking up.
He's the over the road driver. He's picking up photos. They're from
Oh.
North Carolina.
Okay, so father was hauling cars and Juwan stole part of the cargo. So dad said Juwan was sitting in the car when he was preparing to load onto his truck and he took off in it. So, yeah, so dad had to finish the transport and he's in North Carolina, but willing to pick up Juwan. Well, all right, Juwan, you are threatening suicide, which is going to be a great concern. And so I want to go ahead and order a psychological evaluation. I think we need to do this just to make sure. All right. And I don't know. It's bad enough that you ran for the cops. When you make those comments after that, it just, remember, there's no situation in life that's so bad that it can't get worse. You just made that a little bit worse. So anyways, clearly you put the public in danger, put yourself in danger. I'm not comfortable releasing you. All right. So I'm going to go ahead and order you detained. All right. And let's see. So at this point, that concludes my portion of the detention hearings. Judge Porter is here. That's going to continue with the rest of the detention hearings for the day. Thank you, Judge Porter.
Thank you, Judge Kim. Good morning, everyone. All right.
Good morning.
Sergio Alonso Hernandez.
Your Honor, we waived.
He cannot waive. He's on level 2.
Oh, okay. I thought they had to be on level 3 not to waive.
No, they must be on level 1 to earn the right to waive.
Hey, Sergio, I'm sorry I told you we could waive. I thought you had to be on level 3 not to be able to waive, but it's level 2. He's been on level 1 until recently, I think.
All right, are you Mr. Hernandez?
Yes.
Is that a yes, sir?
Yes, sir.
All right, Mr. Hernandez, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. If you're detained, then you must see a judge every 10 business days thereafter. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there is something you want to say, please do not shout it out. Remember, you've got the right to remain silent. Ms. Abels is your attorney. Do you see Ms. Abels on the screen?
Yes, sir.
All right. Mr. Mitchell. I'm sorry. Yeah, Mr. Mitchell. What brings Mr. Hernandez to court today? Is Mr. Mitchell here?
No, he's on vacation. Somebody is supposed to be covering for.
All right.
He's on vacation, Judge.
I got that, Ms. Abels. Thank you.
I don't remember who he told me was covering.
Okay. All right, Sergio, according to the police, you were referred in custody by the Fort Worth Police Department on directive to apprehend back in May for runaway and for 2 new offenses of unlawfully carrying a weapon and evading arrest or detention. According to the police report, at a little after 4:30 in the morning, officers was dispatched to an investigation on 29th Street in reference to someone being shot at. Upon arrival, the police saw 2 males in the street around the corner from them where the original call came from. The officers approached the individual and informed them what was going on. The officers then noticed a black handgun in your pocket. You began to run away, threw the gun in the backyard of a nearby home, and continued running. You were eventually found in the bushes across the street and placed under arrest. All right. So Judge Kim has already determined that probable cause exists to believe that you engaged in delinquent conduct. you were on level 1.0 back on August 7th, but now today you're level 2 acceptable. What happened?
He was talking, Judge. That's all he was doing. He'd been talking the whole time, and then all of a sudden he, gets dinged for talking again.
Well, but you don't go from 1.0 to 2A for just talking a little bit.
I didn't say a little bit. I don't know how much he was talking. And he and I have discussed that. I told him, it's unnatural to be somewhere where you can't talk, but he's somewhere he can't talk.
Sergio, what does your behavior need to be before I can consider your release?
Oh, one.
Uh-huh. And I need you to maintain it for me, right? You haven't done that yet, have you? So what do I need to do?
I guess you're gonna tame me?
Yes, sir. And why?
Come out level 1?
Because you're not level 1. I need you to prove to me, once you prove to me that you can behave in the back, then it gives me reason to believe that you can behave at home, okay?
Yes, sir.
So you haven't done that yet, all right? So between now and 10 business days, 2 calendar weeks, I need you to do that so that Ms. Abels is able to come in here and argue that you should be released, okay?
Yes, sir.
All right, it's in your hands, okay?
Yes, sir.
That'll be the order of the court. Thank you, sir.
Yes,
Thank
sir.
you, Your Honor.
All right, Braden Marquise Hood. Good morning, Mr. Hood. My name is Judge Porter. This is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not blurt it out. Instead, I'll create a private internet chat room for you and your attorney, Ms. Herrick, to talk about what you want to say. That way she can advise you on whether or not you really should say it. Do you see Ms. Herrick on the screen?
Yes, sir.
All right. Ms. Gonzalez, what brings Mr. Hood back to court?
Good morning, Your Honor. Yes, this is Braden's 10-day detention hearing. He was actually referred into our department on July the 25th for the offense of possession of a controlled substance, possession of marijuana under 2 ounces, unlawful carrying of a weapon, and lastly, ag robbery. All of those cases have been referred over to the district attorney's office. According to the police report on July the 24th, 2020, Detective Youngblood and Detective Kidd were assigned to an aggravated robbery that occurred at about 8:46 p.m. at the address of 934 East Copeland Road in Arlington, Texas. Victim reported that she made arrangements to purchase a cell phone from an individual she met via Instagram under the name of Number 5. The suspect reported arriving to this address, and she reported that the suspect arrived in a green Kia Soul. He apparently displayed a handgun and pointed it at her, then demanded her money. Victim gave him her brown fanny pack, which contained $480 cash, an ID card, a food stamp card, and a Cash App card. Victim was described as a driver and a young black male with medium dreads and stated a bad acne. There were 2 other suspects in the vehicle. Both were described as black males with dark complexions and medium dreads. The victim further stated that she possibly knew the suspect from school and described a tattoo on his right forearm that said Trill with flowers. Detectives researched the Instagram name and saw a black male that matched the description. The tattoo could also be seen on the photo. The suspect posted short videos with other individuals in a vehicle that appeared to be a green Kia Soul in the background. Detectives further researched the subject name and saw that his name was Mr. Braden Hood, then that he had prior history involving other prior arrangements made through Instagram, where he was purchasing cell phones or selling cell phones. According to the police report on July the 25th, Arlington PD detained Mr. Hood and another individual. They were apprehended in the green Kia Soul, which was suspected to have been used in the ag robbery. Officers observed guns in the vehicle. At that point, Mr. Hood was arrested and transported over to our detention center.
He has been level 10 since August 1st, is that correct?
That is correct, Your Honor.
And does he have a parent or guardian here today?
Your Honor, his mother was supposed to be available via Zoom. However, I do not see her on here this morning. Her name is Sparkle McGilvery.
Yeah, I remember Miss McGilvery.
Yes.
All right, Miss Herrick.
Yes, Your Honor. He has been on level 10 for 10 days. And his last detention hearing, it's my understanding that Judge Kim, am I muted?
I can barely hear you.
Okay.
Just yell.
Okay. My voice is a little, it's almost gone anyway. He has been on level 10 for 10 days, as he was encouraged to do by Judge Kim at his last detention hearing. His mom is not present today, but he's been in contact with her during the time he's been in detention, and she does want him to come home. She is willing to come up and get him immediately if he's released. And so we do ask for his release today.
All right. Ms. Herrick, I thank you. I want to talk to Ms. McGilvery before I release him. And so because she's not here, I'm going to have to order you, Mr. Hood, that you be detained. However, Ms. Herrick, if you can arrange for her to be here to talk to either to myself or Judge Cherry or Judge Kim, because we need a little bit more information from her, then we especially request that.
And so as another detention hearing or as just a appearance in court?
At another detention hearing,
Okay.
Especially set detention hearing.
You got it.
But right now, I don't feel comfortable without directly talking to the parent, because she's had some problems in the past, and I want to be able to assess how Mr. Hood has been doing while he's back in detention in repairing that relationship with mom.
Okay.
That's what I'm needing. I need to hear that from mom before I can just let him go. Because she and I've talked before. So anyway, that'll be the order of the court. Thank you, Mr. Hood.
Thank you, Judge. May I be excused?
Yes, ma'am. All right, Damian Lopez.
Yes.
Are you Mr. Lopez?
Yes.
Mr. Lopez, the law says when you're brought into detention, you have to see a judge within 2 business days. If you're detained, you have to see a judge every 10 business days or 2 calendar weeks thereafter. This is your 10-day detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. That'll also get the attention of your attorney, Mr. Green. I'll create a private internet chat room for you, Mr. Green, to talk about what you want to say. That way he can advise you on whether or not you really should say it. Do you see Mr. Green on your screen?
No, sir.
Mr. Green, can you speak up?
I'm right here. I still don't see him, sir.
Keep talking, Mr. Green.
I'm right here. I'm probably at the top of your screen. Now I see him. Now I see him.
All right. There we go. All right, Mr. Lewis, what brings Mr. Lopez back to court?
Your Honor, Damien was referred by the Fort Worth Police Department on July 26th on charges. He was initially arrested on charges of evading arrest and unlawful carrying of a weapon and discharging a firearm in certain municipalities. About a week after that arrest, the police sent in a related charge of aggravated assault with a deadly weapon. Probable cause for the charges, at 4:46 a.m., Fort Worth police responded to the Northeast 27th Street vicinity on a 911 call. The caller indicated that persons were shooting at her. Without further detail, upon arriving in the area, police identified 2 Hispanic male subjects, ordered them to stop. Both fled on foot. A foot pursuit ensued. Officers made loud commands identifying themselves as police, and the suspects refused to stop. The 2 responding officers respectively pursued the 2 fleeing suspects, but a gun was reportedly tossed during one of the chases. A decision was made to concentrate on investigating and apprehending that suspect. I believe that was the prior detention hearing that you heard. While they were apprehending that suspect, police heard 3 consecutive gunshot shots approximately 1 block from their location. Officers located Damien walking on Azle Avenue. Due to his proximity and the time frame when the shots were fired, the officer held him at gunpoint until another officer arrived. And they allegedly located a silver .38 caliber revolver between 2 sets of shorts. The revolver had 3 spent shell casings in the barrel. When ran, the gun was reported stolen in a burglary of a motor vehicle sometime earlier. Damien was taken into custody on the 3 charges mentioned earlier, and police, as stated earlier, sent in an aggravated assault charge in reference to the original 911 caller reporting being shot at by the juveniles while she was calling police to report the theft of her EBT card.
And when he came in on July 26th, did he receive a drug test?
He did, yes, sir.
What were the results of that test?
Positive for benzodiazepines and marijuana, John.
In his favor, he has been level 1-0 since August 7th?
Yes, sir.
And does he have a parent or guardian here today?
No, sir. I spoke with his grandmother this morning, and she had to work, but she indicated a willingness to pick him up if the judge was willing to release him.
Does he have any prior referrals to the department?
Yes, sir. From December of 2019, an assault with bodily injury that was returned to intake with probable cause by the DA's office.
What does that mean?
Supervisory cautioned.
All right. So, Mr. Green, what are your thoughts?
Your Honor, I'd request that you let Mr. Lopez go into the custody of his grandmother, given that he did honor part of his bargain to be on level 1. The district attorney has provided me some of the evidence in the case. I've only been a chance to review a little bit of it. Some of it came in today. But I can't actually speak to the strength of that case.
What bargain with Judge Kim?
Well, it was just be on level 1. He is doing that. He is behaving in the back.
I don't see anything in our notes that Judge Kim made that promise to him.
I don't think it was a promise, Your Honor.
Oh, okay. It was just a general encouragement to get to level 1-0.
Yes, Your Honor, and he's doing that. Obviously, he's not in trouble with staff.
Okay. So he was brought in on the 26th. It took him, the better part of almost 2 weeks to get to level 1-0 when it should have taken 3 days, right?
Yes, Your Honor.
Okay. What does that suggest to me?
Well, he's a young man, Your Honor. He's under a lot of stress. This is a different environment for him. He knows he's in trouble with the law. He's been behaving for Mr. Lewis recently, so that's why I suggest you return him to his grandmother's care.
All right. Let's put Mr. Reed on the spot. Mr. Reed, what are your thoughts?
Your Honor, it's an offense involving a handgun, and I don't think we've really got specific details if the grandmother actually can provide adequate supervision of someone who's fleeing police and in possession of handguns. So I just would say, for the safety of the community, that, you know, we leave that to your evaluation if there's adequate supervision.
Put your hand down, Mr. Lopez. All right. Mr. Reed has a good point that I feel better directly talking with grandmother because 4 in the morning is a little disturbing. 2 guns involved, 2 kids. This is in Kimbo's backyard. There are all sorts of scary things associated with this. Plus inconsistent behavior in detention. And so we need a little bit better proof of his ability to follow the rules in the back. And we need to talk to his grandmother, okay? However, Mr. Green, if let's let him maintain level 1-0 for the next 7 calendar days. And if Mr. Green, you can get grandmother here next Monday. If Mr. Lopez maintains level 1-0 between now and next Monday, then we'll talk to grandmother and see how it goes, okay?
Yes, Your Honor.
All right. But for now, Mr. Lopez, I'm going to order that you be detained, okay?
Thanks, sir.
Hey, keep maintaining level 1-0 for me, okay? That's going to give me a good reason to consider letting you go. But if you're not level 1-0, you're not going home next Monday for sure, okay?
Next Monday, if I'm a level 1, I'll for sure go home.
No, I'm not going to make that promise to you. That's what I need to consider. It's going to depend on how the talk goes with your grandmother, okay?
All right.
All right. That'll be the order of the court. Thank you. All right, Cameron Newton. Are you Mr. Newton?
Yes, sir.
Mr. Newton, this is a detention hearing to determine if you should remain in detention or be released to a parent or guardian. The law says when you're brought into detention, you must see a judge within 48 hours. And if you're detained, you must see a judge every 10 business days thereafter. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, I want you to move your hand back and forth like this. That'll get my attention. That'll also get the attention of your attorney, Miss Keenan Perkins. I'll create a private internet chat room for you and Miss Perkins to talk about what you want to say. That way she can advise you on whether or not you really should say it. Does that make sense? Is that a yes?
Yes, sir.
Good answer. All right, Miss Smiley, what brings Mr. Newton back to court?
Your Honor, Mr. Newton was referred in custody by the Fort Worth Police Department on June the 11th of this year for 2 counts of aggravated robbery. Since that time, Your Honor, there have been 4 additional charges filed by the District Attorney's Office. I'm sorry. There have been 4 additional charges filed by the District Attorney's Office, including engaging in organized, I'm sorry. And burglary of a have an intended other felony, ag assault with a deadly weapon, 2 counts of ag assault with a deadly weapon, and another burglary of a habitation with included other felony. His case has been filed, Your Honor, and he was set for court this past Thursday before Your Honor, and he has been reset for September the 17th. He is due to have a psychological evaluation this coming Friday, and it is due back next Friday. I will be staffing his case on September the 2nd for possible placement options.
All right. And Ms. Smiley, he's on level 3A as of this morning?
Yes, Your Honor. He is on level 3. He's had some hiccups since his last 10-day detention hearing. As I explained, he has been confined due to breaking DNA with another kid he was back there on. He has several not following instructions. With one day he had 9 not following instructions. That is the cause for a majority of his point deductions.
And another day it was like 12?
The highest he had was 9.
Okay, I'm mixing him with somebody else. Mr. Newton, one of the things I need you to do is what?
Get my level up.
Yes, sir. You were doing better last time. What happened? Just a string of bad luck, right?
Yes, sir.
Yeah, but you got to change your luck, okay? If you're not supposed to associate with somebody, it's not worth getting your level knocked down, okay? Because you want to put your lawyer in the best absolute position to argue your case. And if you're level 3, that makes the DA's case really easy. But if you're level 1-0, that makes your lawyer's case better. And do you want the DA's case to be easier, or do you want your lawyer's case to be easier?
My lawyer's case.
There we go. So what do you need to do between now, because I'm going to order you to be detained, obviously. What do you need to be doing between now and the next detention hearing to make your lawyer's case easier?
Get my level up.
Okay. And what steps are you going to take back there to make that happen?
Not breaking DNA.
That's number 1. What's number 2?
Follow instructions.
There we go. And what's the third thing you can come up with?
I don't know.
Well, think about it.
Just doing what I'm supposed to.
There we go. Okay. So what's step 1?
Not breaking DNA.
Step 2?
Follow instructions.
Third?
Doing what I'm supposed to.
All right. Can you do that for me and your lawyer?
Yes, sir.
What happens if you don't?
Detained.
Well, not just that. What also happens? You make the DA's case easier, right?
Yes, sir.
You don't want to do that, right?
Yes, sir.
All right. That'll be the order of the court. Thank you, sir.
Thank you, Your Honor. Your Honor,
All right,
I
thank
believe
you.
that was my last detention hearing or hearing this morning. May I be excused?
Yes, ma'am. Thank you, Ms. Perkins. All right. Are you Mr. Rice?
Yes, ma'am. Yes, sir.
All right, Mr. Rice. The law says when you are brought into detention, you have to see a judge within 48 hours. If you're detained thereafter, you have to see a judge every 2 calendar weeks. This is your 10-day detention hearing. My name is Judge Porter, and we're just here to determine whether or not you should remain in custody or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please, please, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. That'll also get your attorney's attention, Raphael Sierra. I'll create a private internet chat room for you and Mr. Sierra to talk about what you want to say. That way he can advise you on whether or not you really should say it. Do you see Mr. Sierra on the screen? Waving his hand. Raphael, go ahead and say something.
Morning, Mr. Rice. Oh, yeah, I see him now.
All right. Is Mr. Jennings here?
Yes, Your Honor.
Mr. Jennings, what brings Mr. Rice back to court?
Your Honor, this is a 10-day detention hearing. The police report states that on July 23rd at approximately 11:30 p.m., Fort Worth police officers and Fort Worth Fire Department responded to an arson investigation. According to the police report, the victims heard a window break and observed a fire in the front room of their house. The victim reported that they saw a male running from the area. The victim was able to retrieve a fire extinguisher and put the fire out while she was on the phone with 911. Once officers arrived, the victim reported they've had several problems with Jalen Rice, who happens to be the victim's daughter's ex-boyfriend. The victim further reported that Jalen had been throwing rocks and several other items through the windows, and it had seemed to be escalating. The officers were able to review a video of the outside of the home with the victim. The victim was able to observe a male approach the home, light something, throw it through the window, and run away. The victim reported that the male subject was the same height, build, and moved like Jalen Rice. On July 26th, 4th Police Department and Fire Department investigators obtained a warrant for Jalen Rice's arrest. They contacted Arlington Police Department to assist with executing the warrant. Officers were able to take Jalen into custody without incident. It should also be noted that during this allegation of arson, there were approximately 7 people in the home. 3 were listed under the age of 10. On July 27th, Jalen appeared before Judge Kim for an initial detention hearing. At that time, Judge Kim did order Jalen to be detained. Later that day, we received an out-of-custody police report from the Arlington Police Department alleging that Jalen had evaded from officers on February 25th of 2020. Officers of the police report states that officers made contact with Tara Rice, who was Jalen's mother. She advised that Jalen had stolen her car the previous night. She was able to track the vehicle down to the location, and she observed Jalen walking away from the car. Ms. Rice reported to the officers that she attempted to get the keys back from Jalen, but he refused. Around that same time, officers pulled up in full uniform and in a marked police car. Jalen began to leave the area. The officer identified himself and advised Jalen to return. Jalen refused. Officers did attempt to locate him, but were not able to. All these were referred to the district attorney's office. And on August 7th, the district attorney did file a petition on all new offenses as well as a violation of the court order.
Is that Ms. Rice in the conference, in the parents' room?
Yes, it is.
Mom, wow, this is a lot. Tell me what's going on.
Well, I don't know. This is kind of a shock to me, as far as the arson incident and everything, because he's been doing so well. He has a full-time job, so and he works practically 6 to 7 days a week, and works all the way from 5:30 in the morning to 7. So this is kind of like really a shock. Really surprised me when I got the reports.
What about when he allegedly took your car and then wouldn't give it back to you?
That was way back in February. And I mean, ever since then, he's been doing fine. I mean, he's been going to school. He's been doing his online schoolwork. I mean, I haven't had any problems with him personally at home. So I don't know. I don't know where that charge even came from, because that was way back in February.
How long ago did he and this girlfriend break up?
It's been a while. It's been over a year.
Oh, wow. Have y'all sat down and talked about the breakup?
Have I sat down and talked about the breakup?
Yes, ma'am.
No, I don't. I mean, ever since this situation allegedly occurred, the victims have been harassing me. Not only that, they contact.
Well, let's not talk about all that. I want to talk about your relationship with Jalen. So you haven't sat down and talked to him about the breakup?
Yeah, I mean, he seems like he's pretty much over it. I mean, he has another girlfriend, so I don't know why this even occurred.
Okay.
Or why they're alleging this occurred. So, I mean, he's been over it.
Judge,
did you hear, Ms. Rice, did you hear the probation officer's description of things? Of throwing rocks and then escalating?
I did hear that, but they never identified his face. I mean, it could have been, these are all allegations.
Okay. Don't try to anticipate what I'm asking.
Okay.
You're trying to go somewhere you don't need to go. Okay. You don't want to try and minimize the situation. You want to try and be there to help your son. That's where I'm headed with this. And any talk that sounds like it's minimizing the alleged behavior does not get anywhere with me. What I'm getting at is, if he was there throwing rocks at the windows and then it escalates to something else, that suggests to me that he's not over this girl in one way or another. And that maybe y'all need to sit down and talk about that as a family, because you're the parent. You've got a lot more experience. You've probably broken a few boys' hearts in your lifetime, and you're able to explain that situation as a mom, as a parent, to your son, and kind of help walk him through what he's feeling. Right?
Right. I mean, I'm definitely not minimizing the situation. I mean, it's just, we have talked about it. I mean, he seems like when we have conversations, and we have conversations all the time about, you know, what he's supposed to be doing, what he's required to do. You know, we have rules, it's my house, my rules. So he seems like he's over it. I mean, he has a new girlfriend. So I mean, to me, from what I'm getting from him, and I can only go off based on what he's telling me, he's been over it. I mean, like I said, he has a total new girlfriend. So I don't know. All these allegations are a shock to me.
What's he doing out at 11 o'clock at night?
I never said he was out at 11 o'clock at night. I mean, I go to bed at 9, 10 o'clock. I have infant child. So, I mean.
And when he came in on the 26th, he tested positive for marijuana. Where is he getting the marijuana?
Well, he has a job, so he makes his own money. I don't give him any money. Nothing comes from my pocket. So, I mean, I can't contest to that because honestly, I don't give him money. I mean, I can't contest to that. So I can only speak for myself, and I don't give him money. Yet he does have a full-time job.
Okay.
May the defense respond, Judge?
No, sir. I've made my decision. I mean, you're welcome to say something, but it's not going to change anything.
Well, Judge, just for the purposes of the hearing, there is an identity issue with this case, and it'd be best served if Mr. Rice were able to be released so that we can discuss his case and address the situation as best as possible. Your Honor, at the same time, his mom is willing to bring him to court. His mom is willing to take him at home. Like she mentioned, he does work, but I think it's important the court to know that mom is currently pregnant and he does provide half of his paycheck to support his household, where he also has a sister, two brothers. So they're pretty dependent on him, Your Honor. And any considerations of you releasing him possibly on an ankle monitor, if not today, in the future, would be greatly appreciated.
All right, Mr. Rice, you've only been level 1-0 since yesterday. The court, given your history with the Juvenile Probation Department, that combined with the seriousness of the current allegations, the court is not yet convinced that if I were to release you, you would not still be a danger to the community. And so for that basis, I'm going to order that you continue to be detained. You need to maintain level 1-0 for the next 10 business days. And then that'll give the court a good reason to think that if you can follow the rules in detention, then maybe, just maybe, you can follow the rules at home as well. But as of right now, I'm not yet convinced. And so I think right now, on balance, you're still a danger to the community if I were to release you. So that'll be the order of the court.
May I be excused, Judge?
Yes, sir. Thank you, Mr. Sierra.
Yes, Judge. Thank you.
And Ms. Johnson, what is your client's preferred last name?
Signs.
Okay, thank you. Are you Mr. Signs?
Yes, sir.
All right, Mr. Signs. The law says when you're brought into detention, you must see a judge within 48 hours. If you are detained thereafter, you must see a judge every 10 business days. This is your 10-day detention hearing. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. It will also get the attention of your attorney, Ms. Johnson. I will create a private internet chat room for you and Ms. Johnson to talk about what you want to say. That way she can advise you on whether or not you really should say it. Does that make sense?
Yes, sir.
You see Ms. Johnson on the screen?
Yeah. Yes, sir.
All right. Ms. Rojas, what brings Mr. Sines to court?
Your Honor, I do want to let you know that the mother is on Zoom. It's under Familia Science. This is a 10-day detention hearing for Kenneth. He was referred in custody on the 26th of July for a family violence assault caused bodily injury. The mother is the victim on this case. According to the offense report, the Arlington Police Department was dispatched to domestic disturbance in the home. They made contact with mother, who reported that she was missing $250 from her bag, and she confronted Kenneth about the missing money. There was a small argument, and Kenneth told her that he was going to return the money. When he was handing the money over to the victim, he punched and scratched the victim's right arm. He then walked to the kitchen, and she saw him pick up a knife, or saw him with the knife that was blue. The victim explained that she and her mother were in fear when they sleep, because they felt that Kenneth was going to hurt them, so they hardly slept. This was the only physical violence incident on that day. A red mark was seen on the victim's arm. Kenneth spoke with police, and he indicated that when he was giving the money to mom, she grabbed it aggressively, and he grabbed her arm to push her off. He admitted to having the blue pocket knife. He indicated that when he found out police were coming, he went into the kitchen in fear that it would not look good for him. He was placed under arrest for that family violence assault. He had a scheduled adjudication and disposition hearing on the 27th at that initial 10-day detention hearing for prior family violence cases. They were all filed by the district attorney's office. So he has a family violence assault from February of this month, where an uncle is the victim. He has an assault caused bodily injury and an injury to a child or elderly where the grandmother is the victim, and obstruction or retaliation offense from the same day, which is March the 20th, 2020. That was the petition that was on file, and we were scheduled for the adjudication on the 27th of July. But obviously that was passed because he came in over that weekend for this current family violence.
And have you talked to the family? Do they want him to come home right now?
I spoke with mother today, and she's indicating that she's ready for him to come back.
Okay.
This new case is still pending with the district attorney's office, and we don't have a new court date on the prior family violence cases.
All right. He has been level 1-0 for the last 3 days.
Yes, since the 7th.
Okay. And Mom, are you ready for Kenneth to come home?
Yes, I am, sir.
Are you worried for your safety or any of your family if I were to release him to you?
I could be lying if I say no, but at this point we have had conversations, and I'm pretty sure he's learning his lesson out of this.
Okay. Ms. Johnson, would it disappoint you for me to say that I'm inclined to release him?
No, it would not.
Okay. Have you, Ms. Johnson, had a chance to speak with the family at all?
I've spoken with my client, and I spoke with mom right before he came back in.
All right. Is your client ready to work with the family to start rebuilding his relationship with his family?
Actually, he indicated that to me, so I'm going to go with a yes. I did not initiate it. He started it.
Even better. All right. Mr. Sines, I'm going to order that you be released. It will be on an electronic monitor, okay? So you've maintained level 1-0 in the back for 3 days. I expect you to maintain level 1-0 at home for your family. Will you do that for me?
Yes, sir.
All right. And Mrs. Sines, it is your responsibility to make sure he gets back to court when he is supposed to. Do you understand?
Yes, I do.
All right. Will you work with Ms. Johnson to make sure that Kenneth comes back when he is supposed to?
Definitely I do.
All right. I agree. All right. That'll be the order of the court.
Thank you.
Thank you.
And Ms. Rojas, I've already signed the EM order.
Okay, thank you.
All right. All right. Are you Ms. Ugoagu?
Yes, sir.
All right. My name is Judge Porter. The law says when you're brought into detention, you have to see a judge within 2 business days. And you have to see a judge. If you're detained, you have to see a judge every 10 business days thereafter. This is your 10-day detention hearing to determine if you should remain in detention or be released to a parent or guardian. You have the right to remain silent and not say anything at all. If there's something you want to say, please do not shout it out. Instead, move your hand back and forth like this. That'll get my attention. That will also get the attention of your attorney, Mr. Mooney. I'll create a private internet chat room for you and Mr. Mooney to talk about what you want to say. That way he can advise you on whether or not you really should say it. Does that make sense?
Yeah.
Do you see Mr. Mooney on the screen?
Mm-hmm. Yes.
Yes, what?
Yes, sir.
Thank you. All right. Mr. Howard, what brings this young lady back to court?
Yes, Your Honor. This is another 10-day detention hearing on Thursday, June 25th. 16-year-old Uchi Wago was referred into custody by Fort Worth PD for a directive issued by the court. On 4/19, PO received a text from father over that weekend stating that she had ran away on that Sunday evening. And that was the cause of the actual DTA. On 4/20, PO received a call from the father stating that he had found out that she purchased a ticket on a Greyhound bus to Minnesota using her credit card, using his credit card without permission. Moving forward from there, on May 7th, the prosecutor, Miss Andy, she actually recorded for the offense and for the credit card theft charge.
And this young lady has a relative of some sort living in Minneapolis?
Yes. Mom actually should be on the actual call. Dad as well. I see both of their names there, but I know mom said she was having a meeting at 11:45. She was going to still try to jump back on, and father as well. He should still be there. I see him still there. So.
Yeah, there's
I'm
Miriam.
here.
Where did Dad was? There he is. Okay.
His name is there, but he hasn't popped up. I will.
Yeah, I just sent him a message to try and get him back on the screen. She was supposed to meet with the Alliance for Children.
Yes.
How'd that go? Without going into specifics of what they talked about, because remember, we're being broadcasting.
Well, in actuality, it didn't go, Your Honor, because apparently on July the 15th, so I spoke, we actually had another hearing, 2 different ones, a director by the name of Ms. Lindsay DeLucci said that she was going to talk to Judge Kim to get further detailed information, even though after he actually ordered it, but since then they actually canceled it 2 hours prior to her actual interview.
Who canceled?
Alliance for Children.
Did they give you a reason as to why they canceled it?
The reason was they needed to seek more information. It was, well, it says Ms. Dooley wanted to reach out to Judge Kim to get some clarification on what, if any, additional information has come to light that has changed the need for a forensic interview.
Yeah,
that's what they left.
Do you have any evidence that they have reached out to Judge Kim to make that request?
No, Your Honor.
Neither do I.
Yes, no, Your Honor.
All right. Is the correct pronunciation of your last name Ms. Osamor?
Correct, yes.
Are you here in Tarrant County?
Nope, I'm in Minnesota.
Okay, okay. And so it is Dad who lives here in Tarrant County?
Correct.
Okay. Golly. She's been level 1-0 for a good long time.
Yes, yes, Your Honor.
And golly.
Your Honor, also, she has a court scheduled on the 12th. I will say that I've been in contact with her attorney as well as the DA, Miss Andy. Mom is scheduled to be available, well, to arrive actually tomorrow. It was some indication that they considered to dismiss the actual case if she's actually returning to Minnesota with her mother.
That's correct, Judge.
Okay. Well, then that makes this easy. Ms. Osamor, you are planning to come to Texas later this week?
Tomorrow, yes, sir.
Okay. And wow.
Judge,
okay.
Judge, if I could interrupt.
Please.
I have an agreement with the prosecutor that if she returns with her mother, that the prosecutor will dismiss the case.
Okay. Mr. Mooney, are you available to help the DA walk that dismissal through tomorrow, and then we can expedite her release from detention?
Yes, if somebody needs to notify me.
All right. Mr. Reed, will you let Ms. Smith know about that?
I will, Judge.
Ms. Osamor, once you get to juvenile tomorrow, please go see Ms. Smith. And then Ms. Smith can walk through other paperwork. Ms. Smith can also get in contact with Mr. Mooney, and we will expedite things. All right?
Okay.
Will that work for everybody?
Yes. Yes.
Mr. Reed, any objection?
As to the plan, Judge, no, but that's an agreement between defense counsel and another prosecutor, but I will inform them that that's what the plan is.
All right. Okay. Now, Ms. Ogawagu, for today, I'm going to order that you be detained. But your attorney and Ms. Smith have apparently reached an agreement with your mom. And so if they get all that paperwork to me tomorrow, and I'll be here tomorrow, then it looks like everybody's plan is for you to be released to your mother tomorrow.
I don't get to Texas till in the evening on tomorrow. So I was hoping to get to court on Wednesday morning.
All right, then Wednesday. I will be here until 5 p.m. on Wednesday. I usually get here between 8 and 8:10. So I'll be here. And if I have to stay here through lunch to make a family reunification happen, I'm happy to do that. I see that Mr. Ugawagu has turned on his microphone. Can you hear me, sir? Dad, can you hear me? Oh, well, anyway, for now, I'm going to order you to be detained, but it looks like you may be getting out on Wednesday. All right, that'll be the order of the court. Thank you.
Thank you,
Thank
Judge.
you so much.
Thank you, Ms. Osamar. Thank you, Mr. Mooney.
Thank you.
All right, please do not bring the next child in. While these hearings have been broadcast on YouTube, Texas Family Code, Section 5408, subsection C, requires courts to close hearings to the public when the children involved are under the age of 14, unless there's evidence that the needs of the public outweigh the privacy interest of children under 14. No evidence showing the needs of the public outweigh the privacy interest of any children under 14 for the remaining hearing or hearings. Therefore, the court will be discontinuing the live broadcast.